Hope you are all having a great Sunday. I am Manoj. Now I'm back with Indian Penal Code 1860, the second episode, set 2 of set 8, for the purpose of CS Executive Exam, June 2023, coverage with concepts and charts. Now, let me give a few recap on the set 1. Wherein we have said about the fundamentals of Indian Penal Code 1860, the criminal offense, civil wrong, crime, and the fundamental elements of crime, and we also have said the jurisdiction of Indian Penal Code, subject jurisdiction, territorial jurisdiction, intra-territorial jurisdiction, extraterritorial jurisdiction, and we have also said the stages of crime and various punishments prescribed under Indian Penal Code 1860. Now let us quickly delve deep into the set 2. The set 2, the first portion is of criminal conspiracy, which is under section 120A, and its punishment is prescribed under section 120B. Now, let us look at what is the definition of criminal conspiracy under section 120A. Here you would have seen that two or more people, they are pushing hard to push a car. Yes, two or more persons, they are agreeing to do or cause to be done an act, illegal act, or an act, not illegal act, but by illegal means. Such an agreement is known as criminal conspiracy. രണ്ടോ അതിലധികമോ ആളുകൾ ചേർന്ന് അവരെ എഗ്രി പண்றாங்க உட்கார்ந்து they are agreeing or causing to be done ஒரு ஆக்ட் அது இல்லீகல் ஆக்ட் ஆகலாம் அல்லனா ஒரு ஆக்ட் அது இல்லீகல் ஆக்ட் கிடையாது பட் பை illegal means. Such an agreement is known as criminal conspiracy. Here, one of the most important case law were R. Venkatakrishnan versus CBI. The Supreme Court reiterated all this element. To remember this case law, just remember that this case law was a part of Harshad Mehta's scam, wherein Venkatakrishnan is appellant and CBI is the defendant. Venkatakrishnan was a UCO Bank general manager. Harshad Mehta scam, you all know that, I believe. Now, here Supreme Court reiterated two or more persons, they are agreeing to do or causing to be done an act, illegal act, an act not illegal act by illegal means. Such an agreement is known as criminal conspiracy. Now, இது பனிஷ் ஆகணும்னா to punish under section 120B, there must be a direct or circumstantial evidence to show that there was an agreement under section 120A. Now, what are the type of punishments are there in section 120B? No, here the party has done criminal conspiracy under section 120A, and if that offense, if it is punishable with death, life imprisonment or rigorous imprisonment of 2 or more years. If such an offense has got a punishment punishable with death, life imprisonment or rigorous imprisonment of 2 or more years, in that case, the punishment is same as that of the offense, that punishable in the same manner if he had abetted to such an offense. Now, if it is other than above, other than those cases which we have referred, which is not punishable with death, which is not life imprisonment or rigorous imprisonment of 2 or more years. Now, in that case, the punishment which may extend up to 6 months or with fine or with both. Now, the next portion is criminal misappropriation of property under section 403 and 404. Let us see what is section 403. Section 403 talks about someone dishonestly misappropriates movable property or otherwise convert to his own use any movable property which belongs to somebody else. Right? So somebody takes, that means dishonestly misappropriates or convert to his own use of any movable property of somebody else. In that case, punishment is imprisonment up to 2 years or with fine or with both. Here there are 3 important case laws. Bhagiran Dome versus Abha Dome in the year 1888. Muhammad Ali versus State of Madhya Pradesh 2006 is a very interesting case. Udar versus State of Jharkhand 2003. It's also another interesting case. Now, the degree goes little higher, section 404. Here property includes movable as well as immovable property. Here someone dishonestly misappropriates property or convert to his own use any property, knowing that such property was in possession of a deceased person. The owner of the property, the case, imprisonment which may extend to 3 years and fine. Here it is and. Now, assume that the offender at the time of, the offender at the time of such person's death was an employee, right? Here, which also was an employee. Then the imprisonment which may extend to 7 years and fine. Now let us look at few illustrations. These illustrations are given in the Indian Penal Code, and of course in our book also it is there. Here, someone dishonestly misappropriates a movable property or convert to his own use any movable property. Assume that A takes possession of a property which belongs to Z in a good faith. Do you feel that it is offense of theft? No, it is not guilty of theft. Here, after discovering his mistake, he dishonestly appropriates the property for his own use. That becomes guilty of theft. Now, Mr. A, he becomes friend of Z. Z owns a library. Now, Mr. A takes a library without the consent of Z because he is a friend. He has got an implied consent of Z. Is he guilty? No, he is not guilty of theft. Now A goes to the market and sells that for his own benefit. Here it changes the nature, it becomes guilty of theft. Now A and B joins together and they go to the market and purchase a horse. So they become joint owners. A takes the horse for his personal use for some time. Is he guilty? No, he has the right. He is not guilty of theft. A goes to the market and sells it and takes the money for himself. That becomes guilty of theft. Sometimes the timing also matters. Let us look at the timing. I'll tell you. Here, he was having his morning walk on the main road. At that time, he found a government bearer note lying on the road which belongs to Z. He takes it and puts it in his pocket with an intention to return. Is he guilty? Not at all. He is not guilty of them. Now, A has got an emergency need. He immediately goes to the banker and pledges this government bearer note belonging to Z in the bank. But anyway, he has got an intention to return it later to Z. But is he guilty? Yes, of course, he is guilty of. Now, it is not necessary that somebody should know the owner of the property. Let us see that case. Here, A is a lucky fellow. He was walking on the road. He now gets a golden ring. Not knowing it was lying on the road. He takes it and puts it into the pocket. Is he guilty? No. He's not guilty of theft and he has got an intention to return it. Now he goes to the jewelry and sells it. Then he becomes guilty. He is guilty of theft now. Now the case law. What I said, the three case laws which we will look into later. This relates section 403, right? The movable property, either dishonestly misappropriated or convert to his own use. Let us now look into it. Here, Supreme Court held that in Bhagirath Dome versus Abad Dome in the year 1888, criminal misappropriation takes place. Sometimes what happens, the movable property, you get it innocently, it comes to you and you take it. Later on, you come to know some new fact that it becomes more worthy or something which you were not acquainted previously, and subsequently you had a change of mind, right? Change of intention. Then the retaining become wrongful and fraudulent. Next is Muhammad Ali versus state of Madhya Pradesh. Here, Muhammad Ali, he is an appellant. Now let us look into the case. Muhammad Ali went to the scrap vendor and purchased 15 bundles of electric wires loaded on his auto rickshaw and parked in front of his house. That time the Jabalpur police came, arrested on allegation that electric wires were Rs 1800 seized from an auto rickshaw which was parked or stationed outside the house of Muhammad Ali. Now, a revision petition was filed by Muhammad Ali against the order passed by Judicial Magistrate First Class, framing charge under Section 403, misappropriation of movable property. Now, it was held that by Supreme Court, Electricity Department denied of having any theft taken place from their stores. Moreover, the appellant is not having a receipt. Moreover, the appellant does not have a receipt, cannot be said that guilty of offence punishable under Section 403 of the Code. So the order framing the charge was quashed by the Supreme Court and the accused was held not guilty under Section 403. Now the next case is UDER versus State of Jharkhand in the year 2003. Here, Bokaro Steel Plant, they awarded a contract to TISCO, you know, Tata Iron and Steel Company. Here, TISCO, the contract is such that TISCO will supply the part. The erection and will be done subcontracted to the Tata Construction and Projects Limited. Tata Construction and Projects Limited, further they gave a subcontract to Singh Constructions and Company. Now Singh Construction Company, they have completed the work and they have demanded for the money for the completion of work. This time, the payment was not made. Then the criminal complaint alleging that the contractor, since the contractor received the payment from the principal, they misappropriated the money. That was the criminal complaint registered by Singh Constructions and Company. The magistrate took cognizance of the case and High Court refused to quash the order of magistrate. They maintained the same and then further appeal came to the Supreme Court. Supreme Court said that it is a matter of civil nature and not the criminal nature, and criminal complaint was not maintainable and was liable to be quashed. This case is liable to be quashed. Now, Supreme Court also observed that the money paid by the principal to the contractor, main contractor, was not money belonging to the complainant Singh Constructions Company. Hence, there was no question of misappropriation at any place. Now, the next is a small illustration. It's not a case law, it's a typo. Here, Z, assume that Z is a semindar and he is in possession of furniture, money and property, etc. All movable property, immovable property, etc. And Z has no relatives and he dies. At that point of time, A, Z's servant, he takes the possession of furniture, money, property, etc. Is he guilty of that? No. He has a moral responsibility to keep it safe. But when he dishonestly misappropriates it, the nature changes and he is punishable under Section 404. Or otherwise, when he converts to his own use, then the nature changes. He is punishable under Section 404. Stringent punishment is there, right? Because he is an employee. First of all, the property whom it belongs dies. Then the minimum punishment is 3 years and fine. Another thing is that his servant also at the time of death. Now the punishment is up to 7 years and fine. Right? With this, the set 2, that is the episode 2, comes to a closure. I will upload the set 3, that is episode 3. Thank you so much. Thank you. Have a happy reading. Wish you all the best.